I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are back for another compilation video. This will be number 55. And today, all of our judges, no surprise, is going to be coming all out of the state of Michigan. Now, we know that's where we get a lot of our sovereign citizen cases from. Who knows why so many sovereign citizens are in Michigan, but they are. But before I give you the rundown on the judges, just know that there will be no commentary at the end of this video, and also chapters will be added for your convenience. Now, with that being said, let me give you the rundown of the judges. The first judge courtroom that we will be in will be that of Judge William McConico. Second, we will be in the courtroom of Judge Mark Slavens. And last but not least, we will be in the courtroom of Judge Sean Perkins. These three cases, definitely classic episodes that we shared in the past that I'm sure some of you may not have seen and some of you may have. And, you know, it's just going to bring back to your memory some wild moments that we've seen here on the channel. So with that being said, guys, let me get out of the way so you guys could go ahead and check out number 55.
Sir.
Colonel Michael McQuarrie, appearing in appropriate persona.
All right. To my understanding, sir, you filed a motion to have Judge Bryant disqualified from the case. Judge Bryant denied your motion, and essentially your motion was appealed up to the chief judge, which is me. Is that correct, sir?
That's correct.
Okay. Argument.
Well, the argument is, sir, under Michigan Code of Judicial Conduct, the judge is in violation of Canon 1 and 2 because I'm here falsely accused for a 21-year-old warrant. And I tried to speak, and she acts like Judge Judy. She just constantly cuts you off, is threatening, so far as be quiet. Like, I mean, Canon 2, it says public confidence in the judiciary is eroded by irresponsible and improper conduct by judges. A judge must avoid all impropriety and appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. A judge must therefore accept restrictions on conduct that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly, Judge. And I come into court very respectful. I'm a 51-year-old man, and I respect the system. But I'm feeling that I'm being given, disrespect. I'm being silenced. I mean, I have a right under the free speech to petition the court for redress of grievances and things of that nature. And if you look at the TV show Judge Judy, this is how she acts, Judge. Totally wrong. And she asked me, what did I want to do with the case? I said, I would like to challenge jurisdiction because I went to prison in 2002 for 15 years and 8 months. They had under the rule, it's, I believe, for misdemeanors, 40-something days, for felonies, it's 6 months. So I request that the prosecutor prove its authority in bringing these charges so late. And I have been home 6.5 years, productive in the community, no problems. And I'm trying to do right, Judge. I made past mistakes when I was a young man, and I'm just being treated like I'm just a criminal. I'm supposed to be innocent until proven guilty, right? So I'm not trying to disrupt this court. I'm not trying to cause you guys hardships or anything, things of that nature. And my due process is being violated, Judge. That's all. I want to just get this case so it wouldn't be left alone. I'm a grandfather. I have children. And their DPD has retaliated against me, Judge. And I know this is a Detroit police court, and I would like an investigation as to things that's been going on by the prosecutor's office, because Kim Worthy and her subordinates are retaliating against me. There's actual proof. At this point, I don't know if you're familiar with Bill Proctor. He's representing me in this matter and another matter so far as investigations for years of, hardships and tyranny committed against me by the system here in Wayne County. So this is all I want, a fair shake judge, a judge who's going to give me due process and give me what I'm entitled to according to law. And that's it, sir.
Okay. Ms. Ritter, would you like to respond in any way?
Judge, the only response that people have is that this is a case from 2002. It's a misdemeanor assault and battery case. Judge, from my recollection of the prior hearing with Judge Bryant, I do believe, if I'm not mistaken, that it was an arraignment process. And as the court was trying to proceed with the process, I do remember Mr. McQuarrie interrupting the judge while she was trying to make the record. But the people have not gotten to the point where, because Mr. Carnell was disruptive during the proceedings, the people didn't get to the point where there was another pretrial date set where the people could actually see if we're able to move forward on this 2002 case, Judge.
May I have a rebuttal?
Yes.
Okay, Judge, I would like you, if it's possible, I know you guys are on Zoom, so you should have access to recordings of these hearings and things of that nature. I believe that the prosecutor just fabricated facts to you because I was not rude to this lady. All I asked her is, like, she said, what do you want to be done with this case? I said, I would like to challenge jurisdiction. And Michigan and federal law requires once jurisdiction is challenged, it must be proven. How is it that the prosecutor knows statute of limitations? They're licensed. I'm not licensed. I've studied for years in prison. And they don't know that there's a statute of limitations. This is vindictive prosecution because of my complaints against Kim Worthy, Your Honor. And the record will reflect the evidence. And I object to her statements.
All right. Court having had a chance to hear the arguments of the moving party, as well as the arguments of the prosecutor. The moving party is asking for a recusal or to have Judge Bryant disqualified based on Michigan Canons 1 and 2, based on that she is biased, as well as is not allowing a person to be able to basically argue their case. The moving party is stating that he wants to challenge jurisdiction and that he was not allowed to do so. The prosecutor is stating that there was only a proceeding at an arraignment and that the prosecution hasn't even got to the point where they have established whether they want to move forward with the case, but that was not allowed to happen because in their view, there was disruption in the court and there was a breakdown. The moving party is disputing that. He's saying that you could even that I could go to the video or the tapes to dispute that. At this time, the court is not going to make a decision at this point. I am going to pull the tape, pull the transcript. I'm going to make a decision very quickly on this. I'm not going to let this continue. And even based on, the court does have an opinion probably on the likelihood of prosecution on a 21-year-old case. So we're going to come back on, we're going to come back on July 6th at 10 a.m. Please check your schedule, sir.
May I also, you say July 6th, sir?
Yeah.
Okay.
Yes.
May I also, if I may,
check your schedule first. Check your schedule to see are you available for that time.
I'm available. I'm stuck here on tether, sir. I'm available at any time you guys want me to.
Okay. All right. Well, put it on your schedule for 10 o'clock on July 6th.
Okay. Can I say one more thing? If you look at Crampton versus Michigan Department of State 395, Michigan 347 at 351, it says the United States Supreme Court disqualified judges and decision makers without a showing of actual bias in situations where experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. And I'm not saying like trying to attack Judge Bryant or whatever else, but she has an attitude like Judge Judy. She just cuts you off. And I'm just like, so when she kept doing it, this is when I objected and asked her to recuse herself.
And sir, and again, as the chief judge, I don't have to have a showing of actual bias, but perceived bias, something in the fairness of justice. That is my standard.
All right, you can call Ms. Tubbs' case.
Okay. Calling case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815. William Glenn P. 36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary Tanae Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yeah. Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Your Honor.
Okay, then it says, at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Your Honor.
Yes, Your Honor.
And the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No, ma'am.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What day?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under Code UCC 1-207. And I have the rights to represent myself and waive all counsels knowingly, willingly, and intelligently. And I would like to.
All right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm going to voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, you know, once I get that, then if she wants to represent herself, then we can, you know.
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
That's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, Would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Your Honor.
So, ma'am, I'm gonna have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not gonna do it, but I just want you to talk with him and understand some of the risks of doing this. And, okay?
Your Honor, I understand all the risk and I do not wish to talk to him. I have not talked to him in 6 months, so why would I need to talk to him now? Thank you. I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him, is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're gonna need you to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions, just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I am
affirm.
here to, I'm here
All right,
to reserve
let's
my
have you
right.
raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you. All right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not
But I need to
having
know
you
what
present
oath,
yourself.
what oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right, well, let's have her raise her hand again and you say the oath, the affirmation. It's not an oath, it's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No, yeah, okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary affirm.
All right, thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
Well, I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
Punishable up to 5 years or a
It's-
fine not.
Ma'am, just wait. Let me speak, okay?
I'm
Madam
sorry.
it would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice. So that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5 years.
All right, ma'am, the maximum possible sentence in this matter is 7.5 years because you are a habitual offender second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay, so ma'am, first of all, can you give me your educational background?
I have
How far have you gone in school, ma'am?
college.
College, okay. And have you represented yourself before?
Yes,
And why do you wish to how many times have you represented yourself?
twice.
Okay, and then what were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract with you all as owning our vessels, and I'm tired of it. I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
The elements of this offense is that it's punishable by imprisonment for more than
No, that's not what the
Oh.
the elements of the offense are.
the elements. What do you mean
Yeah.
by elements? Because y'all
Well,
use double language.
that's the problem. You
Y'all
don't
use
know.
double language here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense? How are you going to do that, ma'am, if you don't even know what you have to defend against?
I have to offend against the accusations, the charges.
All right, ma'am, tell me what the rules of, do you know the rules of procedure?
The rules and procedures to this is
Yeah.
that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm a judge, okay? Ma'am,
Okay, so what?
ma'am,
so
no,
what-
you don't get to quiz me. Ma'am, what do you know what the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
Acceptance of the hearsay. Hold on, I want to write all this down.
I'm sorry. No, I'm asking you. You say you know this stuff. How are you going to represent yourself?
You got
don't even know what.
acceptance of hearsay, sir. I would like to write everything you're saying down so I can
Have
be
you
able
ever
to.
have you ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No. Do you know how to ask them questions?
Yes.
And how to do the jury instructions? All right. Do you know how to preserve issues for appeal?
Yes.
Do you know that self-representation is almost always unwise?
Yes.
Did you know that the first day of law school, they tell us that he who represents himself has a fool for a client? Do you know they tell us that?
Yes.
And so what does that tell you if they say he who represents himself has a fool for a client? What's that tell you, ma'am?
You know what it tells me?
Yeah,
That
what's
you
that tell you?
You all operate in trade secret acts. So
Okay.
you
Well,
will be
that's
a-
not true, but okay. Miss Tubbs, would you do brain surgery on yourself?
Why would I do brain surgery on myself?
Yeah, because you'd have a fool for a patient, wouldn't you?
Correct.
So why do you think you can do law if you can't do medicine?
Because I go by federal law.
Okay. You understand you'll receive no special treatment and you can receive no help from the judge during the trial. You understand that?
I understand.
You understand the prosecutor is an experienced trial lawyer who is unlikely to give the defendant any special consideration. Do you understand that?
Yes.
You understand you'll receive no special help from the court staff, and you'll be expected to follow the same requirements that apply to practicing lawyers. You understand that?
Yes.
Madam Prosecutor, have I complied with MCR 6.005?
Yes, Your Honor.
All right, ma'am, do you believe that your waiver of an attorney is knowingly, intelligently, and voluntarily made?
Correct.
And accurately and understandably?
Yes.
Okay. Then the court will find that the waiver is knowingly, intelligently, voluntarily made. The waiver is unequivocal. You understand the disadvantages of self-representation, and self-representation will not disrupt, unduly inconvenience, or burden the court. So I'm going to grant your request to represent yourself, ma'am, okay?
Thank you.
All right. Now we've got a jury trial. What's our date?
And I would like the full discovery package sent to me, please, as well with along with the Dr. Chef report
Can you
and the
get her
oath of
whatever
office,
discovery
please,
you
so I
have?
can know what I'm dealing with.
All right.
Do you guys
You'll
just go
set-
by maritime law or common law?
Ma'am, it's not maritime law. You need to learn the law, okay? I'm
Well,
not,
I
I'm
know
not advising you on the law. I told you, I'm not advising you. If you don't know what it is, that's up to you to find out. I'm not advising you on anything on the law, ma'am.
Don't worry about it. I know what it is.
Yep, don't ask for any special consideration. You have to perform just as any licensed attorney would here. So if you don't know that, I would strongly recommend you have an attorney represent you if you don't even know if it's a maritime law or not.
It's my right to ask questions.
All right, well, go ahead. As I said, he who represents himself, he or she is a fool for a client, ma'am. Okay, we will have the attorney send you those documents. Madam Clerk, if you can get a standby counsel for this for March 17th at 9 o'clock. Is there anything else we need to take up?
So am I here released?
Yes, you're released.
Thank you, Your Honor.
Your Honor,
But you need to send all the materials to her. And
Your Honor.
also, if we can get her brought here from the jail, Madam Clerk. Okay,
that's what I was going to ask for, is to have her written here and then another date before the trial date where standby and Ms. Tubbs would be here, where we would all be on the same page.
well, we're gonna get the standby and do that right away as soon as we get that.
Okay.
I
We can
request that,
schedule this for, ma'am, don't interrupt me. I don't interrupt you, you don't interrupt. All
excuse
right,
me.
we'll schedule this for February 19th at 9 o'clock for assignment of a standby counsel, okay? And if you can make sure that she is on Zoom that day, Madam Clerk. Okay, is there anything else we need to take up with regard to Ms. Tubbs' case? And you, ma'am, just so it's clear, you're under oath, you are requesting that there not be an insanity defense. Is that correct?
That's correct. And I also,
Okay.
February 19th,
Madam
I
Clerk,
have
if you can
something
prepare,
scheduled at 9.
ma'am, don't interrupt me. Prepare an order that says that she's withdrawing any insanity defense. Okay, all right, what, Ms. Tubbs?
I have another court time at 9 a.m. on February 19th.
All right, then we'll make this February 20th at 9 o'clock, all right?
Thank you.
What is your date of birth, Mr. Gray?
Good afternoon, Your Honor. 72 is my date of birth. I have a.
Can you say that again? Go ahead, say what you were about to say.
I have a motion before the court, Your Honor.
Let me first start. Do you need a lawyer, sir?
No, Your Honor.
City of Detroit versus Christopher Gray. State your name for the record, please.
Christopher Lamar Gray.
All right, today is the date and time set for a pretrial, and then there's warrants on the other matters. I'm gonna enter a not guilty plea on your behalf. I'm gonna give you a $0 bond. And I'll recall the warrants. What is your motion, sir?
I have a motion to strike and dismiss.
What are the bases?
Basis of federal rules of civil procedure. Number one, there's no claim. There's no ratification of the claim.
There is a claim. There is a. You want me to read out I waived the reading of the information. You want me to read the allegations that have been made into the record? Do you need me to do that?
No, I don't. No, I don't, Your Honor.
I deny your motion on that basis. What else do you have to say? What else?
You deny my motion because of what, Your Honor?
Yes.
There is no real.
I deny your motion because there is a and this is criminal procedure, not civil procedure. But I denied your motion because there is an allegation here.
You're saying, Your Honor, you're saying this is a criminal matter?
Yes.
Okay, well then we need the corpus delecti. And so that's what I'm asking for. If there was a criminal matter, basically what you're telling me is that something has happened, someone has either been damaged or someone has been or either someone has been damaged or someone has something has been come up missing. And if that's the case, then that means that there is a crime. And if there's a crime, then there is the what do you have that's saying that I did the crime? What you're saying that I created this crime that hurt this person. And if I hurt this person and I created the crime, then a third thing that you have to have is the identification of the person. You have the identification of the person, which is me, but you don't have a person saying that they were hurt or damaged, or the crime that's saying what I did to hurt or damage the person. So how do you have a crime?
Okay. You went to law school?
No, Your Honor, I have not.
And where did you get that from? Where did you learn all that?
I've been studying for quite some time, trying to understand what's going on. I have a different perspective as to what's being said that happened. I'm understanding more the procedure that is necessary for a crime to go for them to bring a crime forward. I'm understanding that a bit more.
And where did you get that understanding?
I've done some Cornell law studies. I've also sat down with a couple of friends who have had some issues. I picked up wherever I could, just started to study the law. I just started to go back through Cornell law, started to figure out what was going on and to understand the nature of how what a crime is and everything else. So just a course of me searching it out.
And you're citing Cornell law for all of that you just said to the court?
No, what I did, Your Honor, was I realized that one of the biggest portions that you have to have is you have to have the corpus delecti. And that is in when you're being charged criminally.
What is a corpus delecti?
What do you mean, what is the corpus delecti?
What is your understanding of what corpus delecti is?
That is the corpus delecti is the law that's saying that there is a crime that's being committed. So in order to do that, you have to show the corpus delecti, which is you saying this is what happened. This is how this person was damaged.
So
there is no
the
person.
Officer on these dates, because I got a lot of them, said that
I object. I object. The officer works.
Don't interrupt me.
I apologize, Your Honor. I apologize, Your Honor. My apologies.
The officer says that you drove a vehicle that wasn't registered and wasn't titled, or titled and or untitled, that you drove without a valid driver's license, that you drove without valid insurance. Again, on a different occasion, they allege that you drove without a valid driver's license and no insurance. And then on a different occasion, they allege that you drove without unregistered or untitled or both, and drove without a valid driver's license, repeat offender, that you failed to have a trailer plate, and that you failed to secure a load on your vehicle. And on another occasion, on the same occasion that you failed to secure, that they allege you failed to secure the load, failed to have a trailer plate on your vehicle, that you didn't provide a valid driver's license. So those are the crimes. And in state of Michigan, whether you agree or not, they are crimes. So based on your motion and all of that stuff you talk about, corpus delecti and things like that, the court denies the motion. Okay, based on those reasons I just said. Now, how do you want to move forward? Because wait a minute, I'm not finished.
My apologies, Your Honor.
How do you want to move forward? Because in my experience, someone that comes into court, as you do, you do not want to take an offer. You do not believe that you need to have plates or registration or insurance. And you just disregard all of that portion of the law, and either you are going to move forward by having a trial, or you're going to take a deal. What do you want to do, sir?
Your Honor, first I want to put my objection on the record. And at that point,
whatever your objection is noted. What do you want to do, sir? Do you want a trial? You have two options: trial, or you want to take a deal.
Your Honor, I request a jury trial.
A jury trial.
A jury trial, yes, Your Honor.
Very good. Ms. Mathis, I need a jury trial date. Please.
And if I may, Your Honor, what time is Mr. Gray presently docketed?
I don't even think it matters, but I'll tell you. I don't think it matters. He's got the newer cases and the older cases are pre-trial at 8:35. Christopher Lamar Gray, and then he had some in warrant status. I counted 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases into the record. You know what I want to ask, Mr. Gray, and you can choose to answer it or not.
Yes, Your Honor.
But what I surmise and what I've heard, and I don't know if you're alleging the same thing, is that and you basically did allege the same thing, that no crime has been committed because no person has been, the people of the state of Michigan are in danger of you driving without the proper documentation or anything like that. But I don't, and I'm gonna surmise, and you can correct me if I'm wrong, that you're gonna say that there's no jurisdiction to be able to pull you over because no one has been injured. Is that correct?
I think that what I'm saying is that the city of Detroit had an officer pull me over to say that you're not following these rules. And my stance is, okay, well, then that's fine. If we're following rules, then therefore, let me make sure that you as well as are following the rules, because if I don't do that, then freedoms are lost. So that is that is the way that I proceed, to say, okay, well, then if we're playing cards and we playing show me yours, if this is your hand, then this is mine, and let's proceed accordingly to the law. That's it. That's my only standing, is if someone doesn't stand up every once in a while and define the edges, then they all disintegrate and people lose rights.
And you know something? With that being said, I would agree with you 1,000%. That's why I pride myself, and I hope I'm doing a good job for the citizens that come in here, and the police for that matter, and the prosecution, that I am calling the balls and strikes right. And if something doesn't proceed as it should, then I will dismiss the case one way or the other. But in my short time on this bench, And in my time at practicing law as a defense attorney, I get this, you know, they can't pull me over. I've heard the corpus delecti, first time the civil procedure has been thrown at me. But from from the way I see it, is that you just don't feel that the police have a jurisdiction to pull you over for these issues. Is that correct?
Do I have what, again, Your Honor, what I feel is that if we are following rules, that if I have to follow the rules, and every person out there, all of these officers, everybody else has to follow the rules. So if it comes down to it,
what I'm gonna hope that you do by the time you come back on the trial date, jury trial date is gonna be strike that, March the 18th, 2025.
Thank you, Your Honor.
You're probably gonna have an audience because everybody follows me on these cases all the time.
I understand.
All right, and I don't know if that's what you want, but we're gonna do that.
It's not that.
March the 18th, 2025. We're gonna have a final pre-trial date. Final pre-trial. This is to you, Mr. Bowman, especially the day before on February 17th, 2025 at 8:30. So Mr. Gray and Mr. Bowman, Mr. Bowman, I need you to have all your officers appear on that date. Who's ever going to state these allegations, so that we know that we're not just summoning the people of the city of Detroit to a jury that's not actually going to go. So all parties must appear, and that can be via Zoom. And the trial is going to be in person. All right. All parties must appear on final pretrial date and obviously on the trial date. And what I would implore you to do is you need to figure out the right game, because it doesn't sound like you're playing the right game.
I understand, Your Honor. I appreciate, first and foremost, let me say, I appreciate the dialogue. I appreciate you sitting here and engaging with me at this level. So I recognize what you're saying, and so I guess it's to the table we go. So
yeah, but get your game in order, because I'm just giving you a little heads up. If you come in with that game on the jury trial date, then more than likely you'll lose, unless you can find one of those jurors or a couple of those jurors, or even all of them, to have some sympathy for you, sir.
I got a whole basis for understanding, and so yeah, if you know it.
Well, that basis that you outlined shortly today is not. What
was flawed in my what was flawed, Your Honor? What is
we already discussed it. We already discussed it. The federal rules of civil procedure that you brought up as a motion to dismiss, not the right basis. The corpus delecti, they do have a corpus delecti. They do have a crime that they say has been committed. And if you read the MCL, the Michigan court rules, and the Michigan statutes, then you'll see those crimes outlined there. They have them on the tickets. They got the statute numbers that are on the tickets. So that's not the right basis. So you're in a whole different ball game, and you need to come on to this ball game here.
Okay. All right. Okay. Well, I guess we will have that discussion again. I appreciate it. I also want to say I recognize and honor your compassion that you sit on the bench with. I see it as you go out here and you judge our people, and so for all of that, kudos, man. That's for where you sit. I appreciate that. Thank you, sir. Appreciate it.
I appreciate
that.
Sir. Mr. Gray,
yes, sir.
You have a safe happy holiday season, sir. And
you as well.
Best of luck to you. I'll see you back on March the 17th, 2025 at 8:30 for a final pretrial. And let me say this, let me add to the record.
Yes, Your Honor.
if there's any motions, those motions need to be in
10
writing.
days, within 10 days.
Let's put that on the record to a motion date. Those motions need to be in writing. Have those motions to the court by February 14th, 2025. And the response will be February 21st, 2025. And I'll rule on those motions on the final pretrial date of 3/17/2025. Again, all
Thank you,
parties
Ryan.
must appear, Mr. Kaufman, all right?
I'm not threatening you. Say one more word and that's 30 days. 30 days.